Hello everyone, we are going to do a video presentation for Business and Corporations Law.
We are 5 group members and we are going to present 2 court cases.
The first court case is Australian Security Investment Commission versus Jody Rich.
And the second case is Australian Safeway Store versus Mrs. Aluzna.
As we are 5 group members, we are going to discuss 2 different cases in 2 different groups. Thank you.
My name is Mohit Saini. My student ID SKO30376. Today we are going to discuss a case about ASIC versus Rich. This case happened in 2003, and the case of ASIC versus Rich went to the court when Australian Securities and Investments Commission sued the directors of OneTel telecommunication company for failing to fulfill their duties of care throughout the months that lead to collapse of the company in May 2001. The case against Jody Rich and Mark Silberman was dismissed after 9 years of legal proceeding when it was ruled in Supreme Court stating that ASIC failed to prove their argument and failed to provide enough evidence of their case. The facts about this case is that the business judgment rule had been in question in this case since the beginning. The facts of the case were that the OneTel telecommunication service provider was founded in 1995 in Australia by Rich. Their operations were expanded overseas in 1998, and within the next year, their shareholder James Parker's News Corporation invested $600 million to their business. This helped OneTel to become the 4th largest telecommunication provider in Australia. With 3,000 employees and operating in 7 different countries. Parker's Corporation withdrew their financial support in May 2001, after which the OneTel collapsed. They said they had an underwritten rights issue and claimed that OneTel needed $300 million to survive. The rights issue, however, found that the assistance of the major shareholder and Parker would have been enough to keep the company running until November 2001. ASIC raised and obtained criminal warrants and against the directors of OneTel after it was shut down. They had to freeze. They had the freezing order of Rich's assets and documents of Parker and other shareholders. ASIC brought a claim against Rich, acquiring them of failing to exercise their duties of care towards the board of directors by not informing them of the sufficient material information and the company true financial condition, especially in the time that lead the withdrawal of rights issued and collapse in 2001. The compensation was sought as well as lifetime banning of OneTel telecommunication directors. Further on this case, my colleague Mr. Osama Rashid will continue.
Thanks Mohit. My name is Muhammad Osama Rashid and my student ID is SKO30344. Now I'm going to tell you about the proceeding and rulings related to this case. The duty of care and diligence stated in section 180 subsection 1 of the Corporation Act 2001, saying that the director or officer of a corporation acts as a power and discharge which has been given to him according to his duties with the degree of care and diligence that a reasonable person would exercise if they were a director or officer of a corporation, occupied in officer or held by and had the same responsibilities within the corporation as the director. This argument was accepted in court as it was concluded that the responsibilities mentioned in the Act referred to the responsibilities gained through the position in the corporation and expectations kept from those arrangements, such as Mr. Greaves. A reasonable cause of action was brought against Mr. Greaves under the evidence submitted by ASIC, which is Australian Securities and Investment Commission, providing the obligation and responsibilities that the chairman held as a part of the corporation. Jump to the conclusion of this case. Justin Robert Austin, which is the judge of this case, concluded that ASIC failed to provide key witness and failed the case miserably. And tell us Section 180, subsection 2, which provided a defense to the director breaching their duties, as well as chairman had special powers over the non-executive directors. On the top of that, Austin judgment and ruling wasn't considered technically satisfying because it missed out the distinction between the Section 180 subsection 1 and 180 subsection 2. Basically, subsection 80 and subsection 1 tells us about the standard of care that director requires when performing their duties. And section 80 subsection 2 is about directors' belief and loyalty toward best interest of the corporation. According ESIC, director failed to exercise section 80 subsection 1 and failed in financial position of the company, but the evidence were not accepted by the court. So the defendant in this case are the director which won the case, so on the basis of their defense of doing so in the best interest of corporation. Now I would like to call Asmat for the further discussion. Thank you.
Thank you, Osama. My name is Muhammad Azmat. My student ID is KAC3164. Today I am here to conclude the Australian Security Investment Commission versus Joderich. Joderich won the case as per the section 180 subsection 1 because Australian Security Investment Commission didn't provide even enough evidence to the court. There is no point to prove that Australian Security Commission is given the right document for the case. As per the Joderich section 180 subsection 2, court has given the case to the Joderich and Joderich won the case. Thank you.
Hi, myself Syed Abdi and my ID is DEU3042 and I'm here to discuss a case about Australian Safeway Stores versus Zaluzna, which was happened in 1987. And the case was filed under occupiers liability where the plaintiff slipped on a Safeway supermarket floor on a wet morning. It was a rainy day outside and there had been water on the floor of supermarket. When Zaluzna went into the supermarket, she walked over the floor and fell due to moist film on the tile of the supermarket floor. An employee of the store was ordered to mop that floor and excess water was carried in by the customer. It was argued about the dampness and moisture that could be considered in order to rule whether the claim is permissible in court or not. It is reasonable to know that the number of people entered in a supermarket with wet shoes and clothes when it's raining can leave water and moisture on floor. However, the extent of the moist would be a greater indicator to analyze the danger. It was to be plaintiff. The judge was uncertain about the part of the floor where Ms. Zaluzna fell was not clearly mopped. In the case, Zaluzna and her action in damage was dismissed because the court held the duty as owned by the inviter to invite. The part that the supermarket played was to ensure that reasonable care part for their safety and the occupier play their part by preventing damage for themselves from such unusual danger. And for the rest of part, I would like to invite my friend Waqas. He will going to tell you.
Thank you, Wasik. My name is Waqas Arshid and my student ID is SUP3031. For the further proceedings in this case, Mrs. Zaluzna filed an appeal in the full court for the same case, and the case was decided under the occupier's liability. For this case, a case between Mr. Dongu and versus Mrs. Dongu versus Mr. Stevenson was cited, and which was established to establish the duty of care. By the duty of care, the facts of that case was that Mrs. Dongu consumed a bottle of ginger beer, which had a snail in it. Because of having snail in the bottle, Mrs. Dongu fell ill and brought brought an action against Mr. Stephen, the House of the Lords. Then the House of the Lords, found that the injury was can be reasonably foreseeable by Mr. Stevenson. It is highlighted that the reasonable care should be taken under the to omit such kind of acts against neighbor. By the neighbor, we normally means the person, the people who are in the immediate vicinity or the nearest ones, or the someone who can be directly affected by your actions or within your premises. The case established the law. That case established the laws of duty of care and the negligence towards the occupier. The person who has occupied your property and you have the directly and reasonably prevent the risks to ensure the injury is made to them on your premises. So the decision of the appeal was that the plaintiff had the directly standings in the case as she entered the shop, and the defendant owed her duty of care to prevent any injuries or risks to injury while on their premises. The duty was breached by the defendant because it was the defendant, it was the Australian Safeways duty to prevent any kind of risk for its customers. That any kind of damage happen to its customers. Thank you.